everyone had a good summer break. And if it's your first time with us, welcome. We're glad you're here. As always, the format for this is we go ahead, we introduce the speaker. We'll have the speaker go on for about 30-ish minutes. Then we'll have kind of a Q&A period. And then at the end, if there's any announcements on NESA's part or the council's part, we'll do those. And that's basically it. So I'll go ahead and I'll kick us off with an introduction to our guest today. Today, we're really excited. We have Mr. Michael Huston. Mr. Huston is an assistant to the Solicitor General at the United States Department of Justice. And what that means is he represents the federal government before the Supreme Court. So he argues cases on behalf of the federal government in front of the Supreme Court. And in that role, he's argued about 9 cases at this point. He is, of course, an Eagle Scout, and he received his Eagle Scout in 2004 in Arizona. And in 2022, he was named a National Outstanding Eagle Scout in the National Capital Area Council. He lives in Virginia with his wife and 3 sons. He's a PAC committee chair for the PAC, in which all of his sons are Cub Scouts. And with that, we like to let the speaker speak for themselves. So I'll turn it over. Michael, thanks for being here.
Well, thanks very much, Connor and Colin, for inviting me to speak. Thanks to all of you for joining. I hope today to talk a little bit about my career and my work in the law, particularly my work at the Supreme Court and in front of the Supreme Court. But really, I would like to open it up to questions and answer any questions that are of interest to you all about the Supreme Court, about the Department of Justice, about anything that is of interest to you. I'd rather make it more of a discussion than me just talking. But I will start by just telling you a little bit about me and my career path. So as Connor said, I became an Eagle Scout in 2004. I went to the University of Arizona. After Arizona, I went to the University of Michigan for law school. And after that, I started working as a law clerk to 2 federal judges. So the first job I had in law school was a law clerk to Judge Raymond Kethledge on the United States Court of Appeals for the 6th Circuit. The circuit courts of appeals are 1 level below the Supreme Court. So in our system, in our federal system, so we have each state in the United States is
It appears Michael froze a second there. See if he comes back. Sure, he'll talk about it, but he just is actually transitioning jobs. Maybe they cut out his Wi-Fi a little early. There you go.
I just sent him a text. I think we lost him here.
We'll get him back on in a second. While he gets back on, I can actually just slide in and make the brief council announcements I was going to do at the end. That way he has enough time to answer all your questions when that comes around. I wanted to just talk about how we're planning a couple in-person events like Connor alluded to for NESA. One here in October, hopefully a happy hour, and then a larger one in November. So just keep a lookout for those. And it appears Michael has hopped back on, so I'm gonna let him continue.
I'm sorry about that. Yeah, I'm not sure what happened. Okay, so we're talking about the difference between state and federal courts. So federal courts are the courts where cases are heard involving defendants who are charged with crimes against the United States, and also civil litigation that involves various statutes where Congress has conferred federal jurisdiction. In the federal court system, the top is obviously the Supreme Court of the United States. Below that are the United States Courts of Appeals, which are divided into regional circuits. And then below that are the trial courts, federal trial courts, which are called federal district courts. So I clerked as a law clerk to a judge on the Federal Court of Appeals. That meant that I worked in the judge's chambers. I was assisting the judge in sort of all aspects of his work. I was assisting him by reviewing the briefs in the cases. I was making recommendations to him about how he should decide those cases. And then once he had the panel of judges who had reached a decision about how the case was going to come out, I would assist the court by, in some cases, drafting an opinion, preparing a first draft of an opinion that the judges would then edit, and that eventually would go out as the opinion of the court. So that was a terrific learning experience for me. Gave me a chance to work, really see the inside of the federal court system and sit with a panel of judges and learn how it is that they are deciding real life cases. And I think, that was certainly a valuable, I learned a great deal from that about what kinds of arguments convince judges and how cases get decided in real life. After that, I clerked again, and this time at the Supreme Court of the United States. So I clerked for Chief Justice John Roberts. Each of the 9 Supreme Court justices has 4 law clerks each year, and these are 1-year appointments. So you do it for a single year, and they are, like I was, they are younger lawyers who are a couple of years out of law school. And here again, my job as a law clerk was to assist the Chief Justice in all aspects of his duties. So I would again, be assigned to the various cases that would come into the Supreme Court, and I would, well, first, the Supreme Court has a discretionary docket. The Supreme Court gets to decide which cases it will hear each year. So a key part of the law clerk's job is to assist the court with that responsibility by reviewing the requests that the Supreme Court gets to hear a case. Those are called petitions for a writ of certiorari. A key part of my job was to review the many thousands of petitions that get filed each year and make recommendations to the justices about which are the few of them that warrant the Supreme Court's attention. The Supreme Court gets about between 6,000 and 8,000 requests each year to hear cases. It only ends up hearing about 60. So it hears about 1% of the cases that it gets asked to review. And it's the law clerks who take the first crack at advising the court on which cases are sufficiently important that they warrant the court's attention. And that's usually because the case implicates a division among the lower federal courts. So courts have heard, in a situation where 2 courts have heard the same question and reached divergent answers, one of the key functions of the Supreme Court under the Constitution is to resolve that disagreement so that the law is uniform everywhere, right? The Constitution shouldn't mean one thing in California and one thing in West Virginia. And so if you have a court in California and a court in West Virginia that have disagreed about the meaning of the Constitution, the Supreme Court will take the case to make uniform law for the whole nation. That's what we call a circuit split. And that's the kind of thing that, law clerks look for. Also, it doesn't always have to be a circuit split. The Supreme Court also takes cases that are exceptionally important and that implicate, the whole nation. So my job as a law clerk, my first responsibility was to assist the court by going through the petitions to try to find the ones that were worthy of the court's time and attention. And then on the cases that the court had agreed to hear, I would assist the court in coming to a resolution of those questions. And the way we would do that is I would review all of the briefs in a case. I would review all of the relevant legal precedents, the books behind me. I mean, I'm in my office at the Department of Justice, and these books behind me are the United States reports. Those are the books that contain the decisions of all the Supreme Court. So we would review the relevant precedents, we review the relevant statutes, the federal laws, the regulations, anything else that was relevant, and read all of that stuff, and then make a recommendation to the Chief Justice. I would sit in a meeting with the Chief Justice and say, in this case, here's which side I think should win, and here's why. Here's how I would write the opinion. Here's what I think are the key considerations, and so on and so forth. And then after the case has been decided, the Supreme Court, they hear oral argument in the case, and then a few days later, they go into a conference, which is just the 9 justices. There are no law clerks and nobody else in the room. The 9 of them sit together and they vote on how each case is going to be decided. And then once they have voted, the senior most justice in the majority, and the Chief Justice is always the most senior. So if he's voting with the majority, he has this responsibility. He assigns one justice in the majority to write an opinion on behalf of the court. And if the Chief Justice, and in some cases, he will assign the opinion to himself, and then he'll, divide it up among, and he basically tries to ensure that each justice gets about the same number, more or less, over the course of the term. And so if the Chief Justice is writing the opinion, and I was the law clerk working on the case, then I would assist him by doing a first draft of that opinion. And that's a very intense process. We had 10 days to do it. So opinion assignments would be made on a Friday afternoon, and my draft would be due to him 1 week from Monday, 10 days later. So again, that was a very intense 10 days each time of preparing a draft opinion to go to the Chief Justice. And then he would edit it multiple times. He and I would go back and forth on various drafts, and eventually it comes out as the opinion of the court after anybody has written a dissenting opinion or concurring opinion or something like that. So that's my work at the Supreme Court as a law clerk. And again, it was incredibly valuable because I got to know these 9 people and got to see what kinds of arguments motivate them and what kind of legal arguments convince them to rule in a certain way in particular cases. And I was extremely grateful for that opportunity. After that, I worked at a law firm in Washington, D.C. called Gibson, Dunn & Crutcher. By this point, I knew I wanted to be an appellate lawyer who practiced law, a litigator who worked in the higher level federal courts of appeals in the Supreme Court. So I did that. And then 5 years ago, I joined the U.S. Department of Justice in the Solicitor General's office. So the SG is a very important person in the Department of Justice and in the government broadly. She's often referred to as the 10th Justice because of her very unique and special relationship with the Supreme Court. So my office is very small within DOJ. There are only 22 lawyers who work here. There's the SG, there's 5 deputy solicitors general, and 16 assistants to the Solicitor General, which is what I am. Our collective responsibility is to litigate everything in the every case in which the federal government is involved in the Supreme Court, my office and my office alone handles. So that's thousands of criminal cases that come up from anywhere in the federal system, criminal cases that are brought all over the United States. When they get appealed to the Supreme Court, my office handles the briefing. Whenever the Supreme Court grants a case in which we're interested, a criminal matter or a civil matter, when the Supreme Court agrees to review it, we're going to be the attorneys who handle that, handle the briefing and the oral argument. And then we routinely participate in cases as an amicus curiae. That's Latin for friend of the court. And so if there's a case in which we are not directly involved, here's an example. Consider a case where a state court has charged someone with a crime, and that case has come up through the state criminal system. So it might be, Virginia versus Jones, right? And Jones has been convicted by a Virginia state court, and he appeals to the Supreme Court of the United States, and the Supreme Court grants review. We might have the federal government might have an interest in that case, even though we're not a party. The parties to that case are Virginia versus Jones. The federal government isn't a party, but the federal government might have an interest because if it's a case about, say, the meaning of the 4th Amendment or the 6th Amendment, the federal government is obviously also subject to those constitutional provisions. So we would file an amicus curiae brief, a friend of the court brief, attempting to bring to bear our unique expertise with federal law enforcement. And we would want to tell the court, hey, here's how this issue that you're deciding will affect federal prosecutions. And then we would, once we file the briefs, we participate in the oral arguments. So as Connor said at the outset, I've argued 9 cases before the Supreme Court. All of my colleagues argue cases each year. And our goal is to attempt to make sure that when the Supreme Court, which is obviously final, right, decides cases for the entire nation, that it has the full picture of and understands the implications for each of its decisions on the federal government's interests. The federal government's interests can be sprawling, right? We have an interest we want the court to understand how its cases will affect foreign policy, immigration policy, environmental policy, domestic policy. I mean, it goes on and on. criminal law enforcement policy. So we do that by convening meetings with all of the federal agencies or components or portions of the federal government who might have an interest in the case. We bring them together in a large meeting and we all talk about the case and figure out where are those interests. And then my office, takes those views and perspectives that various entities have throughout the government and writes about them in our briefs to the Supreme Court, and then we explain them to the Supreme Court at oral argument. And all of this is designed to ensure that, like I said, when the Supreme Court makes a decision that will rule for the entire nation, that it understands the full scope of its decisions for the American people and for the federal government. And it's because we participate in the Supreme Court so much, we are by far the most common litigant in the Supreme Court. We argue far, far more cases than any other party in the court in any given year. That's what contributes to that 10th justice moniker that I mentioned earlier. The court trusts us because we have a reputation that has been built up over many, many decades of being scrupulously honest with the Supreme Court. Indeed, there's a tradition in the office called confessing error, which basically means even if we have won a case alone, so let's say another part of the Department of Justice was handling it and we prevailed and the lower court ruled in our favor, and then it gets appealed to the Supreme Court and we look at it and we think, you know, although we won, we didn't deserve to. That's really not consistent with the law. We will file something called a confession of error, where we essentially acknowledge that we won, but we shouldn't have, and that the other side should win the case, or that there's some mistake that was made and that the case needs to go back for further argument or further briefing or something like that. It's because we do those kinds of things, and because the justices know us personally as people, they know all of us by name, they see us multiple times each year. It's because of that they trust us to get it right, to be completely honest and forthright. They obviously don't always accept our arguments. You know, we lose several cases each year, but they trust that we're always going to give them an honest accounting of the facts as we see them and the law and the implications of their decisions. And I think, you know, that really connects to being an Eagle Scout. I think certainly for me, something that I learned from my Scoutmasters was the absolute importance of integrity. And, you know, a Scout is trustworthy, and a Supreme Court lawyer has got to be, because again, they know me personally. And if I don't have my reputation with them is literally everything. I mean, if they don't trust me to be honest with them about the facts and the law, then I'm just not going to win cases. They're not going to trust me. They're going to ignore my briefs. They're going to focus on somebody else's arguments, and they're going to roll. And there are lawyers that are known not to be trustworthy to the, you know, at the Supreme Court, and those lawyers, you know, don't do well. So I think it's an example of a profession where one of those scouting values is just of absolute paramount importance and really directly contributes to my ability to do my job successfully. You know, I was reflecting earlier about other lessons that I think have borne on my career from being an Eagle Scout. And I think a couple of them that come to mind are being an Eagle Scout for me was one of the first things I remember that was really hard in my life. It was something that challenged me and that I felt like I had really accomplished something meaningful. And that idea of setting a goal and working after it for years and then accomplishing it and pushing yourself sort of beyond what you thought you were capable of is what I think about when I think about the process of becoming an Eagle Scout. And I think that's a critically important life lesson. And it pushes me in my career now to strive for bigger things, to dream big, you know, to have the dream to work at the Supreme Court, and then, you know, to dream of arguing cases at the Supreme Court, which is something that, you know, just an extraordinarily minuscule percentage of the lawyers in this country can say, you know, have had the chance to do. And so, you know, setting that kind of goal and dreaming big and going after it and working hard for it over years and years and years, I had to do that in order to get in these jobs. And I think I learned part of, chasing those dreams from scouting. So as I said before, I am, happy to continue talking more about my work at the court, my work in front of the court. But really what would be, most enjoyable for me would be to answer questions. So why don't I stop there and see if there's anything that I can tell you about the things that I've done, or the Supreme Court, or anything you want to ask. Feel free. If I can't answer it for any reason, I'll just tell you. So please feel free to ask anything you want. Yeah, Ty.
Yeah, question. What do you think the general understanding is of the public of the court system and their relationship to the executive branch and the legislative branch in this country, the general understanding of what the Supreme Court does?
Unfortunately, I think it's not good at all. I don't think that we do a good job educating our citizens, our young people, about the separation of powers, which is really foundational to our constitutional design, just as you're saying, right? So the framers of our Constitution created a government of limited powers, and a key way that they thought that we could preserve liberty was to divide the federal government's power, not as a sovereign, like with a king, right? But to divide the federal government's powers between the executive, legislative, and judicial branches, and of course, establish checks that each branch has on the other. So the system really, the reason why our Constitution has served us so well for 200 plus years, in my view, is precisely because of that system. And but I don't think it's well understood at all. I think that most people, first of all, most people can't tell you just about anything about who the Supreme Court, they can't name a single Supreme Court justice. Most of them don't know what the Supreme Court does, if they even understand that it exists at all. But what unfortunately, I think even educated people, even college graduates in this country, tend to think that the Supreme Court just sort of sits as like a super policy-making body. They tend to think that the court just rules based on what is its own view of good or bad policy. And that's just not true. It's a cynical and erroneous view, I can tell you, of how the Supreme Court works. There are obviously strong disagreements among the 9 justices about the proper way to interpret the Constitution and federal laws, about about legal methodology, but they're just what divides them is that legal methodology. They disagree about the right way to interpret the Constitution. They don't just sit in that conference room and say, like, I'm a Republican, or I was appointed by a Republican president, so what can I do to help Republican policy interests? You hear so much of that. There's so much of the discourse surrounding the Supreme Court when it makes a major decision, like it obviously did this past June in the Dobbs case concerning abortion rights. Whenever the court makes a big decision and the public does pay attention, so much of what you hear is this idea that these are just politicians and rogues. And it's really not true. The court is the only branch of government that writes a written opinion to explain every one of its decisions. And I think that, they try to promote transparency. They could do things they could do better in that regard. But the court plays an incredibly important role in preserving our liberty by checking the unfettered will of the executive branch and the legislative branch, and particularly at a time of unified government, which we have right now, right? Democrats control both houses of Congress and the presidency. In 2017, Republicans had unified government. So that has, we've had that continuously. And I think you see that when we have unified government, the rights of the minority are often at stake in some ways. And that's true when both Republicans and Democrats have power. And I think a critically important role of the court is to be sort of the steady hand that checks the excesses of pure democracy. I think Dr. Andrew had the next question.
If not, there's a question in the chat from John Birmingham. He asks if you could revamp the US system to be more of a civil law system instead of common law, would you? Why or why not?
Yeah, so the question is about the difference between a civil law system and a common law system. So the common law refers to the idea of unwritten law that has been accumulated over the wisdom and experience of centuries. So it's a very old ancient concept, but like an example is the law of contracts. The law that governs contracts in this country is not, strictly speaking, I'm simplifying here, but like it's not strictly speaking a set of written laws that say in order for contracts to be valid, like this and this and this and this has to be true. Instead, we have a common law of contracts, which has been built up over centuries of judicial decisions and have come to establish sort of uniformly accepted principles. That's the common law tradition. The United States inherited it from England, and we still use it today. The other sort of major legal style of legal system in the world is a civil law system, which is much more about written law, right? In civil law, there's an attempt to codify as much of the law as possible, so that you can sort of actually go and read a statute, a law that's been enacted by a legislature that says, like, if you want to make a contract, this is how you have to do it. In the United States, to know how to make a contract, you'd have to get a treatise, which is a summary of the common law. It's a summary of judicial decisions that tell you the rules for making and enforcing contracts and that sort of thing. That's the basic difference between common and civil law. The question is, would I favor moving the United States to a civil law system instead of a common law system? I mean, that's a good question. I don't know that I have a strong view about that. I'm inclined to say no, because I'm sort of a small C conservative guy. I think the system that we have serves us really well. I think our judicial system is in many ways the envy of the world. People come from all over the world to study our court system, and certainly over the last 100 years, as we've seen emerging democracies and emerging constitutions, those people come to the United States to examine our system, and then they modify it, to suit their own end. The UK Supreme Court, which was created relatively recently, works different from ours in several ways that I think are fascinating. But I think the common law tradition has served us relatively well, as long as, and here's the key kicker, as long as judges understand the difference between common law and civil law. And so we have written law, right? We have the Constitution is our supreme written law. We have federal statutes that are written law. I am an originalist. I am an original public meaning originalist in the mold of Justice Scalia. So I believe that judges have an obligation to adhere their decisions to the text of the statutes or the Constitution that they're applying, and not treat everything as just common law making. So I think the common law system has served us well in the branches of law where it operates, in torts and contracts and things like that. And as long as judges understand that they have that common law making power when it's a common law issue and not when it's a question of constitutional textual interpretation, I think the common law system works well. Mark says he recently had an executive that thought he could wrest the legislative branch to twist facts to his benefit. I assume you mean President Trump, if you mean a chief executive, or maybe you mean something else. But will your office become involved in prosecution of this person in any way? So let me answer. I will answer that at the level of process rather than substance. In truth, I don't know. Like, obviously, I don't have any non-public information about this. The Attorney General obviously, conducted a raid on former President Trump's home related to documents that the government believes are the property of the federal government, and that, as far as I can tell, the former president believes are his property. So there's a dispute about that. I mean, of course, also like there's the congressional committee that's investigating many people surrounding the January events of January 6th, 2021. I don't have any non-public information for you about. I don't have any non-public information, and thus I don't have anything to tell you about what the Justice Department may or may not do. Even if I did, I couldn't share it, but I don't actually know. But at the level of process, if there were, if there's a prosecution in which that implicates the Supreme Court, if there's a case that's going to the Supreme Court, yes, my office will be directly involved. Indeed, my colleagues will be the ones handling that. If there's any kind of case, the other thing we do, in addition to handling cases that are directly in the Supreme Court, we handle litigation that we think has a good chance of going up to the Supreme Court at some point. So it's very common, and I'm just speaking generally here, it's very common for us to get involved in a matter that's in a federal trial court if we think there's a good chance that case could end up in the Supreme Court at some point. That's one of our responsibilities. So I don't have anything to tell you. I really don't know I don't have any non-public information about what the Justice Department would do in regard to either anything related to January 6th or the raid at Mar-a-Lago. I can tell you at the level, as I said, I can tell you at the level of process that if there's something that happens and if there's a case that gets brought and that case goes to the Supreme Court, then yeah, my office would be the one that would handle it. Dr. Andrew? Oh, go ahead.
Yeah, I was just going to say there's a question from Dr. Andrew asking if you could speak about the individual who leaked the decision on Roe v. Wade and what it was like behind the scenes and what the fallout was from that.
Yeah, so I don't know who leaked it. The question presumes it's a law clerk. A lot of people make that assumption. It's a fair assumption. I would just note that we don't know that for sure, and it's not guaranteed because the law clerks, the people who have access to draft opinions at the Supreme Court are the justices, all of their law clerks, but there's also a number of staff members at the court, people who work in like the library, the publications office, which is the part of the court that like puts out the opinions, the press office. So there's a number of other people at the court who would have access to a draft opinion. So it may well be a law clerk. Frankly, it wouldn't surprise me if it's a law clerk. I think that's probably the most likely leaker, but I just caution that I don't know that for sure. I don't know who it is, period, and I don't know for certain that it's a law. Let me speak about that for a minute. I mean, I was shell-shocked when I saw that. I was sitting in this office when I saw that, and I just thought, this is unbelievable. When I pulled up the Politico piece and then the link to the opinion, I knew immediately that it was real because it had all of the I know what draft Supreme Court opinions look like, and it had the hallmarks, all of them. And it would be, too hard to fake that. So, I was just stunned. It's the most astonishing thing I've seen since I, started following the Supreme Court 20 years ago, or 25 years ago. It was like a bomb going off in my world up there. It was a disaster. I think it was an egregious breach of trust. If we find the person, I hope that person gets disbarred and can never practice law again. Because it was just an extraordinarily and unprecedented attempt to inflict damage on the institution of the Supreme Court. And there's no excuse for it. So I'd like to see the person disbarred at minimum and maybe criminally prosecuted if for lying about it. They all, as far as I understand, all of the law clerks subsequently signed affidavits under penalty of perjury attesting that they weren't involved in the leak, and perjury is a crime. So, talk about like a scout is trustworthy. This person obviously was no Eagle Scout. The behind the scenes fallout was rough up there because from what I know, which is secondhand. I have friends. I've sort of been able to pick up some pieces, but I really think that the justices trust each other. they obviously disagree vigorously about a number of things, but they really trust each other and care about each other. They're involved in each other's personal lives, and they have dinner together and they eat lunch together every day when they're in court. And so it was just so unknown. It was unthinkable that something like that would happen. And the whole building really operates with a spirit of camaraderie and mutual respect. And people disagree with each other in good faith. People say to each other, well, I know you think X, but I think Y, and like, this is what moves me. And in the drafting process, they kick around ideas, just like any of us who have been involved in the preparation of draft documents. You do one draft, but then you share it with people and you get feedback, and you want people to give you candid feedback, right? You want people to come to you and say, you know, you made this argument, I don't really think that works, and I prefer if we changed it or took it out, or what if we were to go this direction? And you talk. That's all part of the process of making a good work product, whether it's a brief or a presentation or a Supreme Court opinion or anything else. And I think the ability to do that depends on the ability to give and receive candid feedback. And I think that they felt stunned about that for a while. And there was an immediate era of like, they didn't know who to trust. I think the good news is that is really, we've started to move past that, and that there has been healing. Things always cool down in the summer once they get out and get away from each other. That's why they take the summer. That's one of the reasons they take the summer off. They finish all their opinions in June, and then they go away for 2 or 3 months. And that helps kind of reset and get everybody back for the next session. So I am told that things are getting better, and that they are, those bonds of trust, I think, continue to actually be strong. And there's a real sense within the justices, among the justices, that they're not going to allow this leaker to damage the institution any more than it has already been done, and they're not going to allow that person to sort of fundamentally change the way that they do their work, which is, I think, a good thing.
I think the next two questions can probably kind of be done as one. They sort of work well together. So sort of a two-part question. What is your favorite case that you have personally worked on? And then part two to that, if you could kind of go back in time, what is your favorite case as a student of law, and a case that maybe you wish you could be there and actually have watched unfold?
Yeah. So my favorite case that I was involved with was called Our Lady of Guadalupe versus Morrissey Brew. It's a case about something called the ministerial exception. And it affirmed the constitutional right of religious institutions to select the employees that have key ministerial functions within their religious tradition. These particular cases were about teachers at religious schools, at Catholic schools. And the Supreme Court held that Catholic schools, but this would be true of all faith denominations too, have a constitutional right to determine who is charged with the very important responsibility of educating children in their faith. And so as a result, states and the federal government may not apply otherwise applicable employment discrimination laws. So for the same reason, for example, that there's a federal law that prohibits discrimination on the basis of sex. You can't, if you're an employer, you cannot only hire men and refuse to hire women. But that doesn't apply to the Catholic Church, which has all male priests. And the same principle the Supreme Court held applies to Catholic school teachers, because they have a ministerial function. Their job is to pass on the faith to the next generation. And part of the free exercise of religion that's guaranteed by the First Amendment is the right to select the people who are going to be your ministers in your own faith tradition. I think that was a really important religious liberty case that affirmed an important constitutional protection within the Bill of Rights. And I was really honored to have written the brief that supported the Supreme Court's. The court, we recommended that the court rule that way. We urged the court to adopt that reading. The court ultimately did adopt that reading in an opinion that tracked much of our brief. Many of the arguments that we made to the court in our brief, the court adopted as the supreme law of the land in its opinion. And that's exceptionally gratifying when you work really hard on a brief to present arguments and the court adopts them. My favorite landmark case as a student of the law, I mean, boy, we could go, all day on that. I think it would have been extraordinary to see Brown versus Board of Education argued, knowing about the important role. I think what would have interested me about that is to understand, it's obviously, the court's most important case, or one of them at least. But to one extent, the lawyers understood it that way at the time, and the court understood it at the time. The court understood in Brown clearly that it was making a very important decision for the nation. I don't know if, to tell the truth, if the court understood it was making sort of its most important decision and a decision that would affect the course of the nation for the next 60 years. For that matter, it would be interesting to see in reverse the same thing in Dred Scott, Chief Justice Taney's decision, which affirmed the rights of slaveholders and essentially held that enslaved persons were not people under the Constitution, that they were property. Taney thought that he was attempting, he thought that in his decision he was attempting to prevent the Civil War, but in fact, he directly contributed to launching us into the Civil War. And it would be fascinating. So that's, Dred Scott is the court's all-time worst decision. And it would be fascinating to understand and to just go back and see to what extent the court had an awareness of the consequences of its decisions. Chief Justice John Marshall was our fourth Chief Justice. We call him the Great Chief Justice. He established so many of the precedents that still affect how the court operates today. In particular, the notion of judicial review, the idea that the Supreme Court sits in judgment of the constitutionality of the actions passed by the political branches was not at all, we take that for granted today, that the Supreme Court can strike down laws of Congress. That wasn't like a common thing in 1776. When Marshall ruled in Marbury versus Madison, the case that essentially established the principle of judicial review, he was not creating something wholly new, but certainly he was doing something that was very unconventional at that time. It was not well accepted, but has directly contributed to the separation of powers and established an important part of our system for the next 200 plus years. So it would be Marshall is a lion of the law. He's our all-time greatest justice. And it would be extremely fascinating for me to sit down with him and see to see anything in which he was involved. Dr. Andrew asked if I could watch an old case being argued before SCOTUS, which one and why? So yeah, I think it'd be many of the same answers. Like I'd love to go see Brown argued, and you can listen to it. Actually, if you're interested, you can't watch obviously because they're not recorded, but you can listen. There's a website called oyez.com, OYEZ.com, that has audio recordings of all of the Supreme Court arguments going back decades. So if you want to listen to the original oral argument in Roe versus Wade, you can get it. I don't know how far back they go. I think they go back to Brown that far. I'm not 100% sure about that. But the other thing that would be, fascinating is in the really old days, like in the days when, in the early 1800s, arguments went on for days. And so, today, each case gets about 1 hour. Sometimes they go a little longer. In the last few years, the court has been expanding some of them a little bit. But most cases get argued for 1 hour, 30 minutes for each side. But in the old days, they argued for days. And it would be fascinating to see the different approach, especially as somebody who has to prepare for those oral arguments, right? I spend many, many, many dozens or hundreds of hours preparing to deliver a 30-minute presentation to the Supreme Court. It'd be fast. I wouldn't even know how to prepare for a multi-day oral argument. But I would like to see how it was done.
It's a question that I have. Obviously, you talked about how the justices have disagreements on kind of the process of the law and how to come to a conclusion, and that's why we get opinions that have a 5-4 ruling or something that's not unanimous, I imagine that within your office, those same disagreements exist. And I imagine that, when the government decides we're going to argue one case one way, that case has to be assigned somehow. Is it assigned generally to someone who agrees with it, or is it something where you sort of get assigned the case and it's not necessarily adjudicated that way? And even if you maybe fundamentally don't agree with the case that the government is putting forward, you still have to argue it just to the best of your ability? Or do they assign it to someone they know sort of agrees with that position?
Right. So it's definitely not the case that cases are assigned based on the individual views of the lawyer. So you're absolutely right that within my office, there are a wide range of perspectives. We have people who clerk for Elena Kagan. We have people who clerk for John Roberts. We have people who clerk for Antonin Scalia and Samuel Alito. So the whole range of the court is pretty well represented in my office. We have very conservative lawyers. We have very liberal lawyers and everything in between. But nobody works on cases based on their personal views of what is good or not. We are not policymakers. We are career litigators. So our jobs don't change with each successive administration. The leadership does. The SG is appointed by the president and confirmed by the Senate. But those of us who are working in the office, our jobs don't change. So we're not bureaucrats. We're not members of Congress. And we're not political officials. We don't have a mandate, and nobody voted for us. I guess we are bureaucrats in that sense, but we are litigators. We are not policymakers. My job on a case is to defend the actions taken by the policy branches of government, to defend the statutes that Congress has passed, and if it's a case about executive branch action, like an agency rule or something, to defend the rule that the executive branch has put forward, regardless of whether I think it's good policy or not. And I have certainly argued and worked on a number of cases over the years where I was defending something that I thought was good policy, was bad policy, was something that I didn't agree with, that I wouldn't do if I were the president. But that's not my job. We don't, and that's very important because, when you go to the polls, you vote for a president, and that president has an agenda and a set of things that he is or she is going to run on, and that's what you vote for. You didn't vote for me. And so you don't want the lawyers at the Department of Justice saying, well, I know President Biden ran on this, and but I'm a Republican, and I don't think it's good policy, so we're not going to defend. That's not how government is supposed to work, right? He was elected, he gets to make the law. My job is to defend the actions of the executive branch and statutes passed by Congress, so long as there is a good faith basis for doing so. And that gets back to the point I made earlier about confessions of error, right? If there is a credible legal argument to be made. Now, I would not go into court with an argument that wasn't credible, that wasn't accurate, that wasn't made in good faith. But so long as there is a reasonable defense to be made for our actions, my job is to make the best case the government has to make. My adversary's job is to make the best case for the other side. And it's the court's job to decide what the law is. In the words of Chief Justice Marshall, it is emphatically the province of the Judicial Department to say what the law is. So it's the courts that decide. We are lawyers who make arguments. And thus, in our office, we definitely benefit from having a wide range of perspectives. And we rely on our colleagues who think differently than we do and have different instincts and intuitions about the law to strengthen our arguments, because we want to write a brief that can appeal to as much of the court as possible. But cases are not assigned based on who likes anything and whatever. You do what you're asked to do to the best of your ability.
Thank you. So I think last question here as we get closer to the end of the hour from Dr. Andrew. He wants to know, how does the general public get in if they want to see a Supreme Court oral argument in person? Yeah,
well, so ever since the pandemic, unfortunately, the court has been closed to the public. I hope it will reopen this year. I don't know that for a fact, but I hope it will. once COVID, passes and that we get out of that period, anybody can, you just show up on the day and wait in line. A line will start forming the morning of an oral argument, unless it's like a really, really big case. If it's a really big and important case, sometimes people start camping out a few days later. But for most days, you can go down to the court on the morning of an oral argument. The court starts at 10 a.m. If you get there at like 8 a.m., you just wait on the plaza in line, and they admit as many people as they can take to fill up the courtroom. Since the pandemic started, we've had live audio for the first time ever in the court's history, where the audio recordings are available in real time. You can listen to the oral arguments on the court's website. So if you want to do that, you can listen live too. But if you want to actually go in and see it, and it definitely is a great thing to see. And if you're involved with a scout unit, in the DMV, take your scouts, because I guarantee you will be extremely impressed by the oral arguments, by the whole court building. It's incredible in there. So I highly recommend going down at some point to see a case, and you just walk in. There's no fee. You just wait in line and go see it. And I would encourage everybody to do that.
Well, thank you so much. That's about all the time we have for questions today. But Michael, we really appreciate you coming, joining us, sharing a little bit. And of course, good luck with your next role. I know you mentioned that you're taking on a new role soon here. And so we wish you the best. Quick announcements. I think Colin touched on some. I'll turn it over to him in a second if he has any more.
Yeah.
But we just want to mention, of course, we're doing this every month, the second Thursday of each month. Let your friends know, invite people. We discussed last year, we're keeping kind